Impact of Influence.
Covering true crime throughout the Southeast.
Hello, friend. Matt Harris and Seton Tucker at Murdaugh again. If you are looking for some of the other crimes that have happened in the Southeast that we'll be dealing with, they're coming up. But Murdaugh keeps rearing his ugly head. Where can they find us, Seton?
You can find us on Facebook at Impact of Influence.
And starting up a YouTube channel. But the best way to get to that is through the YouTube channel, or is through the Facebook page. Make sure you rate and share and comment. Much appreciated. We are back talking about Murdaugh because the South Carolina Supreme Court is taking up the appeal of Alex Murdaugh over his double murder conviction, and the appeal based on jury tampering by Becky Hill, the clerk of court during the trial. And to sort this legalese out, we have one of the second best Matts in Seton's life.
Yes, we're pleased to welcome my dad, Matt Siembieda, who has a long legal career. We're not going to say how many years. Graduate of Penn Law School and a professor at...
You better get this right.
Temple. Temple.
Thank you.
I know. I had a brain. My old lady brain just hit me for a minute. But anyway, he's on vacation this week. So we're really super happy that he agreed to join us, take a break from the beach.
Well, thanks, Matt. Appreciate that.
Yeah, I'm at the Outer Banks. So.
Oh, nice.
Yeah.
But you're working for us. I hope shortly Seton sends you your check when we're done here.
Yeah, and probably something that's appropriate for this broadcast of yours is that I actually clerk for an appellate court.
Okay, yes.
So I do have a little bit of insight on the way these things move.
Okay, so let's do that then first. So as people know, Alex Murdaugh, or should know if they've been following this, his defense team had the case before Justice Toll on whether or not Becky Hill influenced the jury, and there's some...
It was like an evidentiary hearing where they brought in the jurors and they interviewed them to find out, what their experience was, if they heard things from the court. So, and the former Chief Justice Toll said that she was relying on South Carolina law, this Green case. And in that case, even if these communications occurred between the clerk of court and the jurors, that they would have to prove that the communications influenced them.
Alex team would have to prove that.
Yeah, they would have to prove that. So there were kind of two tiers.
And we'll get into that legalese there. But what happened then was Justice Toll's like, nothing here, so they appeal again. So you said you worked at the appeal court. So normally, right, that appeal goes to the appeal court. How often do you see the Supreme Court of whatever state or federally say, let's skip the appeals and bring it to us? Is that a common occurrence? I would imagine not.
No, it's somewhat unusual that would happen, but you have to keep in mind several things. One, this does involve Alex Murdaugh, and everything about him seems to be expedited. And it did get a lot of national attention, so that, the eyes of the world, not just of the U.S., are on the justice system in South Carolina. So I think for those reasons, they probably want to move it along. Another important factor here is that there's a new chief judge of the 5-member South Carolina Supreme Court, John Kitteridge. And the first thing that he did was that he started to instill more transparency, more accountability with a code of ethics for the court, and more effort to expedite and move cases along. So that in terms of the time for Murdaugh to have an appeal, he happened to be the ideal chief judge of the Supreme Court to be there at this time.
And it's important to point out that it was only August 1st that he was sworn in. So this is within his first couple of weeks, or maybe even less. I don't know when officially it was out.
And I think we should also point out this Green case that Chief Justice Toll relied on him making her decision, or former Chief Justice Toll relied on making her decision. He wrote the opinion for it.
So let's go to the cases. Explain the difference between Green v. South Carolina and the federal Remmer. So let's start with Green. What is your interpretation of that?
Well, yeah, and I'll do that. Let me just state one thing up front for your
Okay.
listeners, that this appeal does not really deal with the guilt or innocence of Murdaugh. What it really deals with, did he get a fair trial? So that whatever happens here really doesn't decide its guilt or innocence. It's really looking to see under the Sixth Amendment of the U.S. Constitution and the same rights under South Carolina law, did he get a fair trial? That's what we're really talking about here.
Right.
Now, what you're talking about, there was a Supreme Court case called Remmer. And under the Remmer decision, the court found that there was some sort of um, communications to the jury that resulted in a nullification of the verdict in a new trial. And that is the law of the land in the U.S. South Carolina is in federally what they call the Fourth Circuit, and the Fourth Circuit also has cases along the same lines. In South Carolina, there were several cases, and the one that Judge Toll relied upon was the Green case. In the Green case, it involved a situation where one of the court personnel had a communication with a juror about what would happen if there was a hung jury, what would the judge do? And basically he said the judge will give you an additional charge to go back and consider it and do what you can to reach a verdict. And that's commonly called the Allen charge. And that's what he said. And the courts found that that basically was somewhat of a process move, really didn't affect the deliberation or the decisions of the jury, and that therefore that was harmless error and appropriate under South Carolina law. What Judge Toll did is she took that case. Now, what the petitioners or the appellants have argued, the Murdaugh side has argued basically, is that case really dealt with a process issue and doesn't really go to the substance as to what happened with the deliberation of the jury and affect them in that way. And that they're saying that therefore, that based upon that once they established that there was communications with the jurors, and I think 3 said that there were, that then shifts the burden in effect to the prosecution in the case to establish that there was nothing to it. And in this particular case, went directly to apparently, or what was alleged, the clerk, Becky Hill, telling the jurors basically find him guilty in various ways, that's what they're claiming is the reversible error here.
So the burden of proof thing is important, right? Because maybe it's simplifying it, but Green is saying, if somebody says something to the jury, then the defense basically has to prove that it affected them. Remmer says if somebody says something to the jury, then the prosecution has to prove that it didn't taint their decision, which is important because there are a jury, or at least one, that's saying it did change my opinion.
Well, that's correct.
Well,
and I'm sorry, I didn't mean to interrupt you, Seton, but the way the way to think of this is this. Once the chicken is out of the coop, it's a little bit tough to say that, well, it really didn't affect the jurors. If someone of a powerful position like Becky Hill, who now has some 70-some ethics indictments and is being investigated criminally for her conduct around the trial, and she's the one talking to the jury, and Judge Toll herself found her testimony not to be really credible and inconsistent, that tells you that, how can you put the genie back in the bottle? And once the jurors hear that, even though they say it may not influence them, that is what the appellants are arguing, the Murdaugh side is arguing, that should be enough to give them a new trial. I'm sorry, Seton, you were going to say
Yeah,
something.
you're going to say, and I agree. I simplified what she
well,
said. But
well, two things. I think one is that it's debatable about whether these communications influenced someone.
whether
Because
she said that.
one of the jurors, I think Justice Toll found that she did not think that they really influenced them. That is kind of something that's still kind of up for debate, I think, a little bit.
I think now if you asked her, though, the one juror would say straight up.
No, I mean, I think she's gone on record. She's saying it. She tried to submit an affidavit saying, hey, yes, I was influenced by this. But that's neither here nor there. I think the bigger question is a court official who is at the level of Becky Hill, Clerk of Court, having these type of communications, is that some sort of presumed influence?
Yes. And the idea is that once she did what she did, I think it's virtually impossible for the prosecution to say that didn't affect Alex Murdaugh's right to have a fair trial.
So let's say, okay, it goes before the Supreme Court. Well, let me go to another thing. So the end camera stuff that happened during the trial, specifically into the dismissal of the egg juror, all that is sealed. Attorney Joe McCullough was able to see it under the ruling that he couldn't share it with anybody. He's petitioning at some point soon, if he hasn't already, to have that made public. The the prosecution says they don't want that made public. How do you feel that will come out? And will it come out before this goes to the Supreme Court? All that in-camera stuff that has been under seal, and do you think it should be out?
Well, yeah, I think it should be out, but I think that in terms of what's going on now, it doesn't really matter. There was a record that was made below by Justice Toll with the 4-day hearing she had, with the witnesses that were called, with the other evidence and affidavits that were put in, and that's what's going to be considered by the court. And I think what the court's going to be looking to do is to give some strong guidance going forward to the lawyers who practice in the state about what the rules are around these various issues, what the presumptions are, whose burden it is, how far it goes. Is this a process issue, or is it something more than that? That's what I think the court's going to be doing. So I don't think what happened with the egg juror and the release of that most likely will not have really any impact what's going to happen with the Supreme Court.
Well, it was interesting. We didn't hear from the egg juror during this evidentiary hearing, but we did hear from one of the remaining alternate who was still on the jury, or I guess not on the jury. She was the alternate. So we were able to hear from the remaining alternate, and also hear from another clerk of court who was assisting Miss Hill. But we did not hear from the egg juror. So it was just kind of interesting because I thought maybe we might want to hear from her because of the fact that she was privy to some of these communications that may or may not have occurred between the clerk and the jury.
I don't disagree, Seton. I think it would be important and helpful, but basically for purposes of this, and it may come up later on, it might give an additional grounds for appeal by Alex Murdaugh, on what's in there. But right now they have the record just before Judge Toll, and that's what the court's going to hear, and that's what's being briefed, and that's what's going to be argued later this year.
Does it matter at all? We still have this ethics investigation. I believe there's a hearing in December for Becky Hill to go in front of for this ethics investigation, but we still don't really know what's happening with SLED and possibly other investigations into her. Does any of this play into this appeal?
I think probably the only part that's going to play into the appeal is Justice Toll's conclusions that Becky Hill was not believable on a bunch of issues. I think the rest of that will play sort of in the minds of the judges as they think about this, that, hey, listen, we got a clerk of court here who, based upon the way she handled this case, is under multiple investigations, including criminal investigations, for the way she conducted herself. Now, I know that she's denied it and said she's innocent. But with that said, it'll have a indirect effect. I think the more direct effect will be what Judge Toll said, that she found her testimony not to be credible.
So the Supreme Court, let me see the possible things they could do. So they could say Justice Toll read Green wrong, perhaps, and do the evidentiary hearing again. Is that one possibility?
That's a possibility. I think it's more likely that they're going to draw a bright line. And the bright line is going to be new trial and not new trial, and what the standards are.
And there's still other appeals. Like I believe that the defense is seeking to stay the rest of their appeals until they sort this issue out. So there are other issues I believe that they're also appealing, as far as whether the admission of the financial crimes, to the extent that they were, whether that's fair. There are other issues that they're sorting through, but I think that they're wanting to first find out whether this jury tampering on its own is enough for a new trial.
Yeah.
Correct.
Could they? So they don't. They could say new trial, no new trial, but could they also throw it back to another evidentiary hearing?
It's possible, but I don't think, based upon this record, they're going to throw it back.
Right.
I think what they're going to say is they're going to draw some lines here. And I know Justice Toll is well thought of, former Supreme Court Chief Judge herself. But I think that what they're going to do is they're going to look at this very carefully, decide whether or not she was right or wrong, and then draw standards going forward, what courts need to look at in deciding whether or not the trial was fair.
So it kind of gives the new Chief Justice an opportunity to either clarify or make more specific his original writing about the Green case, right? So he because he's so familiar with it, that probably has something to do with this, right?
Yeah, I think so. I think so. And remember, they when they signed their order the other day, they used their discretion under their South Carolina rules. I think it's 204B. So they're using their discretion, and what the rule actually says, I have it up here on my screen now. It basically says that issues of significant public interest or a legal principle of major importance is the reasons why they grant this certification, which they did. So it's of significant public interest or legal principles of major importance, which means they're going to state what the rules and guidelines are concerning these issues going forward.
Gotcha.
Okay, so they're kind of going to make law in South Carolina, like this is how we're going to deal with this sort of thing, right?
Exactly right. Exactly right. And just administratively, for a timing point of view, they then said they're going to file 208A. So which means the Murdaugh side has 30 days to file their briefs, and after they file their briefs, the appellees or the respondents or the prosecutions have 30 days, and then there is an opportunity for the Murdaugh side to file a reply brief in 10 days, which basically means this case most likely won't be heard until December or January.
Well, we do have a brief that's already been filed by the appellate. And actually, in the conclusion of the brief, they say any person accused of a crime, even Alex Murdaugh, has the constitutional right for a fair trial. When a fair trial is denied, he is entitled to a new trial, fair trial. He is not required to earn it by proving that he would have been acquitted had he been given a fair trial at the first time. So
Yeah.
That's exactly right, and that's why I started out at the beginning. And you said it better, and they said it better in their brief. But what I was saying is, this doesn't go to his guilt or innocence. It really simply goes to whether or not he got a fair trial.
Well, and having a fair trial is really the bedrock of the whole system.
it's
Right?
It's kind of crazy. Like, so I've just, we've gotten some comments on our Facebook page, and also just personally, like, why, we all think he's guilty. We've already been through this. What cost to the taxpayers is it going to be to have this whole new trial? But it's really not about that.
That's correct. That's correct. And I mean, there has been some criticism, for example, of Justice Toll. When she reached her decision, she said something to the effect, some are saying that, hey, he would have been found guilty anyways. under our system of justice, I'd like to think that it's broader than that. Even though somebody may be even, quote, a terrorist, an awful person in a lot of ways, under our system, and this is what makes our government unique, is that it's supposed to be fair to everybody. Everybody plays by the same rules. See, and if you recall, when we went to your son's graduation at Wofford, I think the commencement speaker was one of the Supreme Court justices, Garrison Hill, and he basically said the same sort of thing. And that's what we're talking about here.
Well, and another thing that we've heard is, obviously he's in jail for quite some time. He's serving 20 something years for the state financial crimes, and then he's appealing right now his federal court sentence for 40 years for financial crimes. But he's not going anywhere anytime soon, so he's got plenty of time to file these things. Being a former lawyer himself, he's got time to work on it.
Yes.
But yeah, I mean, one of the interesting things down the line for a podcast for you is to think about, if there is a new trial, how's it going to be conducted by him? They probably made a mistake by putting him on the stand. They probably made a mistake by opening up the prosecution to bring in all of his prior acts with regard to all the people that he apparently defrauded. They can now put on a case that may avoid all that. Now they got some problems to deal with, namely around his lies to the government and that tape showing him at the scene shortly before his wife and son were killed. But it would be probably a totally different trial and a much different presentation on his part.
I want to get your thoughts a little bit on this this appeal of the federal court sentencing. So, he received 40 years, and this was there was no trial. This was a plea deal, and in exchange for his cooperation. Now, it was a little dicey when it was about to go down, because Murdaugh failed a polygraph test, which was a requirement of the plea deal. But Judge Gergel said, nope, we're keeping this deal. But then he did an upward variance of his sentence and sentenced him to 40 years. So his attorneys have appealed this, saying it's a violation of his Fourth Amendment rights, being cruel and unusual. And there is a hearing that is tentatively set up October 29th in front of a 3-panel judge in Richmond, Virginia, in front of the Fourth Circuit. So what do you think? Do you think that's cruel and unusual, or that's just, it's the judge's discretion to give an upward variance?
My humble thought is that it's in the judge's discretion to give an upward variance here. You may find the court shave some time off of that, but I think that basically the basic core of what he did will be upheld.
And he waived his rights when he agreed to this plea deal. He kind of waived his rights, saying he couldn't appeal. So I don't know if that plays into it as well.
Yeah, well, the whole deal sort of unraveled a little bit, as you say, with his polygraph test and the judge's upward variance and all that stuff. So the question is because the deal changed so much, and the judge did what the judge did. Originally, didn't they agree to something like a recommendation of 17 to 21 years or something like that?
Yeah, and I believe it was supposed to run concurrently with the state sentence. So I think
about half of what.
Right. 40. I think he was thinking, maybe he gets, he's 54 years old now. Maybe he gets out of jail at the end of his life.
Yeah.
Last few years. I don't know.
Yeah. No, I agree. I mean, I saw. I forgot which one of his lawyers, but one of his lawyers was saying he could get out of jail like in his early to mid 70s or something.
Yeah,
that's wishful thinking.
That was wishful thinking, but it was it was a possibility. I think right now he's throwing anything at the with wall. The wind at the wall and hoping it sticks.
Yeah. And let me just make one other comment about the president appeal, just so it's clear for your listeners. I think the Supreme Court, in terms of what's going on now in the country, in terms of shaking confidence in the judiciary system, and what's going on, particularly in South Carolina, and there have been some issues down there with the legislature, which is dominated by lawyers passing laws.
Yeah.
That affect the justice systems down there. I think the new chief judge and the judges on this court want to try to get the public to develop confidence once again in the judicial system. And I think that's an important thing to keep in mind as they look at this and decide this case.
Yeah, I think so too, because there was the case of the Gerard Price. There was kind of a backdoor deal. It seems like he was let out of prison without. So, and I think that by a judge, and that really, I think, shook the confidence of the citizens of South Carolina.
Well, he used transparency right out of the gate in one of his first
Yeah.
statements. So that's it's good. Matt, appreciate it. Always great talking with you.
Good. And if you need anything more, I'm obviously willing to help. Obviously some of these are just my best guesstimates and stuff like this on what may happen down the line. But I think that it has some basis and reason to it.
We're going to do a whole episode about Seton's stories from her childhood. So
No. No. Go enjoy your vacation. Let's not talk about those.
It'll be a 10-part story.
It could be a whole series.
Enjoy the Outer Banks, Matt. We'll talk to you soon.
Okay, thank you guys. Bye.
All right, bye.
Bye.
All right. You want to join in the conversation?
You can find us on Facebook at Impact of Influence.
And the YouTube channel, getting it rolling. We're working. Thank you for your support. Always grateful that you're spending time with us. Part of the Evergreen Podcast Company. And rate, share, and subscribe. And we'll talk soon, friend.